I understand it, the defendant, I'm sorry. As I understand it, the defendant was represented by Lauren Sharon, who later filed something with the court indicating she was no longer
With that,
with defendant law firm, and that somebody named Nova Levante would be
from Florida.
Attorney for defendant from then on. Ms. Levante then filed a motion to withdraw, which the court denied because she had never filed a notice of appearance.
Right.
Now, I sort of questioned this yesterday, and who am I appearing for? And was told that Ms. Levante was going to file a notice of appearance yesterday. And was still
She's been
attempting to
going to file a notice of appearance for about 2 weeks now.
Don't know if she did that,
No.
Your Honor. It's not on the docket.
Right.
So,
So how did you get here, and where is Mr. Meyer?
I do not know where Mr. Meyer is. I have not seen him. I am here because the defendant's law firm contacted a company called Disappearance, which contacted an attorney in Ohio by the name of Matthew Lombardi, who contacted me and asked me if I would cover the hearing. So that's where we are.
All right. I mean, how can I have you appear for Mr. Meyer if there's no notice of appearance and there's no Mr. Meyer?
I agree, Your Honor.
Okay. Anything you want to say about this?
No, Your Honor. I mean, we're prepared to go forward, I guess.
All right, let's go forward, and you can call your first witness.
Okay. I'd like to call Ms. Ingrid Singleton to the stand.
You can stay right there if you want. Would you raise your right hand? Do you swear the testimony about gives the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, go ahead.
Please state your name for the record,
Ingrid Singleton,
and please spell it for the record, too.
Engran, last name Singleton.
Thank you. And what is your title?
Records custodian for accounts owned by LVNV Funding.
Okay. And what's your job description?
My day-to-day duties include reviewing and verifying the accuracy of the business records and account documents for the accounts owned by LVNV Funding, in preparation to authenticate those same documents, and then anything else the compliance manager tasked me to do.
Okay. And then, so you would say you're the custodian of the business records that LVNV has,
Yes,
especially those that were received upon assignment of the original debt in question?
yes, sir.
Okay. I'm going to hand you what I've marked as Exhibit 1. Your Honor, may I approach?
Yeah. Thank you.
Could you please take a look at Exhibit 1 and tell me in your own words what that is?
This is the charge-off statement, which was the last statement during the life of the loan.
That's that first page we're looking at, right?
That's correct.
Okay. And then what is the charge-off balance?
It is $23,430.86.
Okay. Did Mr. Meyer receive a copy of that?
Yes,
To your
sir.
knowledge? Okay. Let's look at the next page, if you will, which might be blank on yours. I don't know, maybe not. What are we taking a look at here?
This is the payment history.
So this is the entire life of the loan that was opened through the original creditor, is that right?
That's correct.
Okay. Were payments made on this?
Yes, there were.
And what were the amounts of the payments made on it?
$619.19 for the most part. There was one that was $617.98.
Okay. And the very bottom, what was the last payment on this payment history? Do you see where that was?
Yes, sir. It was on June the 9th, 2024.
And what was the amount of that?
$619.19.
So that was the last payment made on this account?
That's correct.
And then again, if we look at the bottom, there's also the final balance there, is that right?
Yes.
What is the balance of that?
$23,430.86.
Okay. Was this document maintained in the ordinary course of business
It was?
through your job as the custodian of record?
Yes, sir.
Moving right along then. I'm gonna hand you what I've marked as Exhibit 2. Your Honor, may I approach?
Yep.
Ms. Singleton, please take a look at that document and tell me in your own words what that is.
This is the bill of sale that shows the transfer of ownership from the original creditor through LVNV's purchasing affiliate Resurgent Acquisitions
Okay, so
to LVNV funding.
this was sold from, or SoFi Lending Corporation, the original creditor.
Correct.
They assigned the debt to your firm, your office, is that right?
They assigned the debt to Resurgent Acquisitions and then to LVNV funding.
Thank you. Skip a couple pages there since you've established that it went through Resurgent, then to LVNV. I want you to take a look at that, what's labeled as Exhibit A in that same packet.
Okay.
And then the following documents, can you please tell me what that is?
This is a printable view of a portion of the schedule of accounts that was purchased in this portfolio, with only the defendant's account being unredacted about halfway down, line number 757. All of the redacted information above and below that belongs to other consumer accounts, and so that's redacted for privacy purposes and has no purpose here today.
Thank you. And take a look at the unredacted part of that document. Whose name is on there?
On the second page of it, you can see that it's Stephen Meyer,
And can you tell me the address as well?
106 Rose Court, Painesville, Ohio, 44077.
And then is there an amount on there, if you keep looking through it? Might be a couple pages down, maybe.
Yes, 1, 2, 3. On the third page, we have the principal amount of $21,602.97, and then the pre-charge-off interest was $1,827.89.
Thank you. Was this document maintained in the ordinary course of business?
Yes, it was.
And as custodian of record, you keep watch over all of these documents, is that right? Make
Yes.
sure that they're accurate?
Yes, I
Best of
do.
your knowledge? Okay. I'm gonna hand you the final document here. Labeled Exhibit 3. Your Honor, may I approach? All right, take a look at what I've labeled as Exhibit 3, and please tell me in your own words what that is.
This is the loan agreement and the truth in lending disclosure.
Okay, and this outlines the amount that was financed by the original creditor, is that right?
It does.
And also the payments that were required from the defendant to make, is that right?
Yes.
As we go through this document, we see some terms and conditions. These are pretty standard, is that correct?
They are.
And does it include documentation or language that shows interest rate and late fees that would be applied
Yes.
according to the agreement?
Yes.
Moving through that, bring your attention to like the third to last page.
Page 10. Yeah.
At the bottom of that, well, what's the name of this page right here that you're looking at?
This is the signature page.
Okay, and at the bottom, does it contain the defendant's signature?
It does.
What's the, just so that we're all on the same page, there's a bunch of numbers below the signature. Can you tell me what that is?
This is a DocuSign signature. So it's like an electronic signature, and that number below identifies the signature as far as the trail goes to know that it was his signature.
Okay, so according to this document, it appears Stephen Meyer did sign this digitally, is that correct?
Yes.
And what day was that signed?
June the 24th, 2023.
And was this document maintained in the ordinary course of business?
Yes, it was.
Your Honor, I'd ask exhibits 1, 2, and 3 be admitted into the record.
All right, they're admitted.
No further questions.
Well, I'm kind of conflicted here, Mr. Robusto, since you're not really here.
Understood.
But you
Your
are
Honor.
here, so if you want to ask any questions of the witness, you can go ahead and do that.
Sure. Ms. Singleton, referring to Exhibit 1 and Exhibit 3, these are documents that were prepared and maintained by SoFi Lending Corporation, is that correct?
That is correct.
Okay. You are an employee of the current holder of the debt, is that correct? Which is LVNV funding, is that also correct?
I'm actually employed by Resurgent Capital Services, who's the master servicing agent for LVNV funding. We're the attorney, in fact, for them.
I see, okay. Do you have knowledge of how these records were prepared and kept by the original creditor, SoFi Lending Corporation?
Yes, sir, I've had training by SoFi.
You've had
Training?
training?
Yes, sir.
What kind of training?
It was a training with our company and their company, their department heads and different departments, educating us on their procedures and processes.
I see. You know what, I have nothing else about it.
All right, thank you. Any other witnesses?
No, Your Honor.
All right. How much you asking for?
Yes, the amount we're asking for is $23,430.86, plus court costs and statutory interest.
All right, anything you want to say, Mr. Robusto?
No, Your Honor.
All right, so I will issue an order, judgment for the plaintiff, $23,430.86, plus costs and statutory interest. And I'll put out a written order.
Okay, thank you, Your Honor.
What was the name of the company that contacted you to be here?
The actual human being who contacted me to be here, his name is Matthew Lombardi, Lombardy. But I believe that the company that contracted him was a company called This Appearance, capital THIS, capital APPEARANCE, one word. And I believe they are a company that assists in getting attorneys to cover hearings.
Okay, I mean, you can do whatever you want. I know you're getting paid to be here, which is good for you, okay? But you could, if you would be so kind as to inform Mr. Lombardi, who can then choose to or not to, let this appearance know that I'm not, from this point forward, I'm not gonna let anybody participate in any hearings unless they're the attorney of record, okay?
Your Honor, I yesterday examined the docket and saw that the court had apparently ordered that attorneys of records be present and
Right.
also clients. So I did notice that. I don't know if anybody else did, but I will pass that on.
Okay, August 15th, or defendant did not report August 14th of 2025 to probation. You understand that charge?
Yes, sir.
Third, positive urine sample on February 17th of this year for cocaine. You understand that charge?
Yes, sir.
We're here for the final hearing. Mr. Roby?
We are going to admit or plead guilty to those violations and offer some evidence in mitigation.
Is that what you want to do?
Yes, sir.
What's your plea to those allegations?
Guilty.
I'll accept your guilty plea and find you guilty. Mr. Roby?
Thanks very much. These are the things that I would say on Jesse's behalf. He's 43 years old. He lives in Chagrin Falls. He's got a very good job with the tree company. I provided some documentation. They still have that job awaiting for him. They have plenty of work. He'd like to get back to work. He has a significant other who's a clean and sober individual. He indicates that prior to turning himself in on February 12th, that he secured an AA sponsor and is more than willing to go and do whatever the court asked him to do as far as meetings. He's had 36 days in the county jail to think about it. His head is cleared. He does have some health, well, I think I shared with you about his father. His father is failing, is in stage 4 pancreatic and lung cancer. He'd like to be able to get back to his father. If I can approach, I have some medical documentation as far as Jesse that talks a little bit about his condition. He's unable to keep a lot of weight on, so it's been quite a difficult stay in the county jail. That kind of his doctor talks about that. So I would ask the court if it would consider releasing him, giving him again the privilege of community control. If the court wishes to extend it, I don't think we'd have an objection on that. And attaching conditions, whether that's an outpatient program or AA meetings. He'll do whatever he needs to do in order to try to get himself back together. Thanks, Judge.
Thank you. Well, trying to think what I could order him to do that he would actually listen to and do. Sit down. You were sentenced on June 5th of 2025. You were given an additional 40 days in jail. So that gets you out about July 10th after you did the jail treatment program, right?
Yes, sir.
Okay, so you got out on or about July 10th after having completed that. And 2 weeks later, you submit a urine sample that's positive for cocaine. Why is that?
I was young and dumb, my mind wasn't clear.
Wait a minute. On July 24th, you're 42 years old. Now you're
Yeah.
43, so you're not young and dumb,
Well, yeah,
okay? That's
just dumb.
That's a horseshit reason, okay? So you just, what'd you do, stare at the wall during the jail treatment program, bide your time, do whatever you had to do and get the hell out of there?
No,
right?
sir.
Yeah, I mean, that's what you did. Why did you then disappear?
I can't give you any excuses of what I did in the past.
I'm not looking for an excuse, I'm looking for an answer as to why you disappeared.
My father had hip replacement. My mom needed my help, and I wanted to take care of my family. And once he was able to help himself a little more, then I could turn myself in and do the right thing.
Okay. And did you talk, so when is the first time after, how often was he reporting, Dave, or Josie?
Sir, he only reported once until he disappeared.
And when was that?
That was on the 24th of July when he reported and tested
Okay.
positive for cocaine.
All right. And who was the PO, were you the PO, Dave?
I was not.
Who
No,
was?
it was Jennifer Harris.
Okay. So I presume you told Jennifer Harris about this family situation that was going on and how it was gonna be difficult for you.
No, sir, I didn't. I was afraid.
Why not?
I was afraid to, sir.
Afraid of what?
I was afraid of the consequences.
No, you weren't afraid of the consequences. Did he have a discussion with you, Josie, about why he didn't show up? What did he tell you?
Your Honor, he told me that he wanted to ride his motorcycle with his father and do cocaine and didn't want to ruin his summer being in jail.
That doesn't sound like anything I would say.
So you didn't say, when did he tell you that?
That was on February 17th.
Okay.
I wouldn't say.
Were you just meeting with him? Was it-
Yes, Your Honor.
Okay. You didn't tell that to her?
I wouldn't tell her I wanted to do cocaine, that's for sure. I wouldn't say that to
Why is
anybody.
she lying to me?
I have no idea.
Okay, well, she's not lying.
I mean, I do wanna ride with my dad since last time, being able to ride on a bike. That's why I turned myself in to do the right thing. so I
Didn't
could
want
get
to
my-
ruin your summer?
No, I wanted to get my life back on track. That's why I turned myself in,
Okay.
do the right
I
thing.
thought the point of, the terms of probation was to give you the necessary tools, I hate that word in this context, but the necessary tools to get your life back in order.
Right.
Wasn't that what it was supposed to do?
Correct.
Okay, so why didn't you take advantage of the tools?
I had family problems and
What?
had family problems and had to take care of my family, you know.
By riding around doing coke?
I didn't have my license. I couldn't drive anything. I haven't even drove my car.
So you weren't riding around on your motorcycle?
I don't have a license.
I know you don't have a license. Half the people out here driving every goddamn day don't have a license, okay?
Yeah.
So are you telling me you weren't driving at all during this time you were gone?
No, I wasn't driving the whole time.
You were not
No,
driving?
No, sir.
Okay. Why do you insist at this point, where you are right now, why do you insist on lying to me?
I'm not lying to you,
You're not.
sir.
And I suppose the next explanation you're gonna give me of testing positive in July and then February is you only use cocaine twice.
No,
No?
no.
How often were you using it?
I was using it every other day.
Every other day? Okay. Well, why should I keep you on probation? Why in the world would I keep you on probation?
Because I'm trying to do the right thing. I turned myself in. I had a lot of time to reflect from my time in jail. I got my head on straight now. I want to become a member of society and do the right thing.
I'm supposed to believe you.
I would hope so.
I don't believe you. Why would I believe you? Okay? I believed you on June 5th of last year. That's why I put you on probation and tried to give you the tools. Okay? Where'd you get your mental health evaluation? You didn't, right?
I went to Dr. Lott,
Who?
Dr. Lott University Hospital.
He did a mental health evaluation?
I believe so.
You mean the Dr. Lott who wrote that
I had a lot of head injuries.
you've got this condition
And
that affects your system as to being able to keep weight on and the frequent eating you need to do?
yeah,
Okay, that Dr. Lott gave you a mental health evaluation?
I can't recall. I mean, I know JTP, they gave me a mental health
Okay,
evaluation.
no, they
too.
didn't. Okay. So what did Dr. Lott say about every other day using cocaine as far as your medical condition?
He told me not to.
Okay. So you don't listen to him either. Who do you listen to? Who do you listen to?
I'm listening to you.
Well, you don't listen to me. That's why you're here, because you don't listen to me. You don't care what I have to say. What I say has no effect on you, so why in the world would I keep you on probation?
Because I want to do the right thing.
No, if you wanted to do the right thing, you would have taken some corrective action after July 24th. Corrective action wasn't disappearing.
That's why I turned myself in. I wanted to do the right thing.
You disappeared July 24th, and you turned yourself in February 17th, and you think you want some sort of credit for that, for
No.
doing that?
No, my father had a hip replacement, and I wanted to help my father.
Why don't you have a driver's license?
Because the courts kept it, and I didn't get to renew it.
What courts kept it?
This one.
This one. I suspended you for a year,
Yeah, I didn't, I didn't get-
effective September 25th of '24. So how am I keeping your license from you?
Well, the warrant for my arrest has the hold on my driver's license, and that,
So you chose to do that. I didn't. I've got nothing to do with your suspension.
right,
So why don't you have a license?
because I had a warrant out for my arrest.
And you had a warrant out for your arrest because you decided you didn't want to play in the whole probation thing. That's why you had a warrant out for your arrest.
Right,
Right. So why don't you have a license? You don't have a license because you decided it wasn't important to get a license. You decided it was important to run around doing coke every other day. That's your priority. Your
It's-
priority isn't your mother and your father. Your priority was you getting high every other day.
well, I've changed my mind, and I had a lot of time to think about it.
Maybe you need more time to think about it. Maybe you need 12 months in prison to think about it. That seems to be what you need. Okay? I mean, you want me to put you on probation, and you blew that off within 2 weeks, if it was even that long. And you want me to do that again? What is it that you think you can accomplish on probation?
I could turn the page, sir.
What does that mean? I don't know what turn the page means.
I could do the right thing,
I don't know what do the right thing means either. Because you've demonstrated that you can't do the right thing.
Not to use
Okay.
drugs.
So what is it, don't give me these platitudes, okay? Don't listen to what the knuckleheads over here are saying, okay? What is it you need to do on probation?
Just to not do drugs and can, yeah.
So how do you propose to accomplish not doing drugs?
Staying away from people and places.
What people were causing you to use drugs in the last 9 months?
It was, people I chose to be around at that point in time, sir.
What people?
People that did drugs, sir.
Who?
Drug people,
Drug people?
yeah.
You were doing drugs with drug people. Who?
Just,
What? I don't know, that's why I'm asking you.
yeah,
Friends.
friends.
What friends?
Some friends that I don't need anymore.
Okay, which friends are those that you don't need anymore?
I can't recall.
You know, I don't have any more hearings today. I can do this all day. All day I can sit here and ask you questions, and all day you can give me non-answers, and then I can do this all goddamn day if you want. Or I can say 12 months and get up and leave and take the rest of the day off. Those are my two options.
Yeah,
I'll tell you what you do. Why don't you take a few minutes, talk to Mr. Roby,
thank you.
who's doing his best to help you, and then I'll come back.
Yes, sir.
Yes, sir. Okay.
So I suppose I have to make it a condition, if I keep you on probation, to stop hanging around certain people.
Yes, sir.
As you said, drug people.
Friends, acquaintances,
Like who?
the normal everyday people that I would, put myself around.
Okay, we're not making any progress since I left.
People I work
We haven't
with.
made any progress since I left.
Some people I work with.
And that you're proposing to continue to work with?
No, sir.
Well, I thought you worked at Tree Service Now Incorporated.
Yeah, I do other jobs also.
Like what?
Subcontract through other companies that I.
How can you possibly climb up and down trees being high on cocaine every other day?
I don't normally use while on the job, on every place.
Okay. So who should I prevent you from hanging around with?
Anybody with family,
Okay.
I mean, if that's what's necessary, sir, then
Well, I'm gonna put there a condition that you can't hang around with family?
my family's my backbone, my support team.
Okay. Is he just not understanding me, or is he just taking the same tack that he took before?
No, Judge, I think that he's taking it seriously. I think it's,
No, I mean, I asked him who I should prevent him from hanging around with, and he keeps giving me everything but the information I'm
You
looking
want the
for.
names. Yeah, here's some of the names.
Yeah.
They're not gonna get in trouble.
Ken West and
And who else you partied with?
his cousins, Cody.
I wonder if these people really exist, or if you're just giving me names for the sake of giving me names. You know why I'm wondering that? Because I can't trust anything you say.
I understand, sir.
Yeah. Anything else you want to say?
No, sir.
Judge, we did have a conversation. He indicates he does have a sponsor. We've talked about the importance of when those temptations do call, that he knows to contact his sponsor, and they talked about, I think he started to talk about people, places, and things, so.
The people, Ken West and his cousin, Cody. The places, wherever, and the things, cocaine. That's what you've been doing a lot of people, places, and things stuff. How many days has he been in there, Josie?
37 on the violation, Your Honor, 112 total.
You said 37?
Correct.
What medication does this Dr. Lot have you on?
What's the medication? Do you know?
Not offhand. I know it's Prilosec 1.
Prilosec?
There's several others that I can't.
How long you been taking that stuff?
I've been taking it for a couple of years now.
Okay. Is the cocaine just like a supplement for you?
It was a
Party drug.
it was a party drug.
I'm always amazed at the guys who have a serious medical conditions and take medication to address the conditions. Figure it's a good idea to mix illicit drugs. Because you see, you want me to be concerned about your medical condition as it relates to you being in jail, but you're not the least concerned about your medical condition.
Um,
Isn't that ironic?
Yes, sir.
Did you pay your fine yet on that OVI?
Not yet, sir.
Why not?
So I wasn't working at the time.
If you weren't working at the time, how are you affording cocaine every other day?
I did some work, but
Huh?
not a lot of work. I wasn't aware of the fine at the moment.
You weren't aware of it. I told
sir.
you what it was on June 5th.
I forgot.
Forgot.
Sir.
Well, you didn't intend to pay it anyway. All right, I'm gonna extend your community control to June 5th of 2030. So your little game cost you another 2 years on probation. 50 days in jail with credit for 37. You're gonna get into an IOP, complete it and follow the recommendations. No drugs or alcohol with screens, not that that means anything to you, but that's a condition. 4 AA or NA meetings a week and a sponsor. You can go to only one doctor, one dentist, and one pharmacy for medication. Take your medication as is prescribed without the supplements. Sign releases, get a valid license. Full employment, get a mental health evaluation and follow the recommendations, and pay the costs and supervision fees. Now, do you intend to do one bit of that?
Yes, sir.
Well, if you don't, guess where the bus is gonna take you next time you're here?
In jail, sir.
No, to prison for 12 months.
Yes, sir.
Anything else, Mr. Roby?
No, sir, thank you.
Swyman, anything else?
Nothing further.
That's it.
That's it.
That's it.
I'm done with the drugs anyways.
Yeah.
13 days is okay, I can do that.
Sir, you can leave the chair there.
Okay, thank you.
Possession of cocaine, a felony of the 5th degree with a forfeiture specification on February 17th, 2026, and we are here for sentencing. In case 26 CR 325, a 2-count information was filed in this case. Count 1 of the information is possession of cocaine, a felony of the 5th degree in violation of revised code 292511 with a forfeiture specification. And count 2, obstructing official business and misdemeanor of the 2nd degree. It is the state's understanding that a defendant will be waiving his right to have the Lake County Grand Jury indict this case and will be pleading guilty by way of information to both counts, and we will proceed to sentencing.
Mr. Mulkey, you represent him on 26-325, is that accurate?
That's accurate, Your Honor. And if I may, I am his standby counsel on 25 CR 001546. He's taken the opportunity to request some advice on that matter, which I gave him, to the effect that there is a pending motion for him to vacate his plea that he entered in that matter. We have since conferenced on a few occasions. I've also talked to his family. It's my understanding that he would be petitioning the court to withdraw that motion to vacate that plea, take responsibility for the items that were charged in that indictment, Your Honor, and proceed to sentencing in that matter, and hopefully proceed to sentencing if the court accepts an information plea and a waiver of indictment in case ending in 325 as well, Your Honor.
Well, I mean, you're not his lawyer on 25-1546.
Correct, Your Honor, thank
Mr.
you.
Liebeck filed a motion to withdraw his guilty plea. So, do you want to address that, or what do you want to do?
Yeah, I just want to take responsibility for it and get it over with and get sentenced.
Well, you've got this pending motion, so what are we going to do with this pending motion?
We got a motion to vacate?
Yeah,
Do you want to withdraw it?
Yeah, I want to withdraw that.
you want to withdraw your motion to vacate the guilty plea?
Yes, sir.
All right, I'll grant that. Let's deal with 26-325. Mr. Liebeck, how old are you?
39,
How far did you go through school?
high school?
Are you a U.S. citizen?
Yes, sir.
Are you able to read, write, and understand the English language?
Yes, sir.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication in the last 48 hours?
No, sir.
Have you ever been diagnosed with or treated for any mental illness?
No, sir.
Did you get a copy of the information that was filed in this case?
Yes, I did.
And is it your intention to plead guilty to count 1, possession of cocaine, a felony 5, and the forfeiture specification, as well as count 2, obstructing official business, a misdemeanor 2?
Yes, sir.
Do you understand you have the right to have the case presented to the grand jury for them to decide whether or not to indict you?
Yes, sir.
Did you discuss that right with your attorney?
Yes, I did.
Are you going to waive that right?
Yes, sir.
Your Honor, I've witnessed the defendant and Mr. Mulkey sign the waiver of indictment, and I'm signing myself.
All right, I'll accept the waiver of indictment. Now, before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you. And I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you questions. If you don't understand the question, then stop me. If you want to talk to Mr. Mulkey some more, let me know, and I'll give you more time. You understand that?
Yes, sir.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes, sir.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine the witnesses. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them testify. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
You have the right to testify at trial if you want to. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, I am.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes, sir.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you could not afford to hire a lawyer, one would be provided at no cost to you. Do you understand that?
Yes, sir.
If you file an appeal, you're entitled to get a transcript of all the hearings in this case. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you could not afford a copy of those transcripts, they'd be given to you at no cost. Do you understand that?
Yes, sir.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes, sir.
Do you have any questions about any of these rights?
No, sir.
Do you still want to plead guilty to these two charges?
Yes, sir.
Do you understand by pleading guilty, you're fully admitting your guilt to the charges?
Yes, sir.
Do you understand by pleading guilty to this felony in count one that you're voluntarily giving up your freedom for whatever period of time I could sentence you to prison, to jail, or to community control?
Yes, sir.
In count one, possession of cocaine is a felony of the 5th degree with a 12-month maximum prison sentence and a $2,500 maximum fine. Do you understand that?
Yes, sir.
Count two, obstructing official business is a misdemeanor of the 2nd degree with a maximum jail sentence of 90 days and a maximum fine of $750. Do you understand that?
Yes, sir.
If you plead guilty to the forfeiture specification, you're voluntarily giving up the items listed in the specification. Do you understand that?
Yes, sir.
I could give you a consecutive sentence in this case. That means one sentence after another for the separate counts. If I did that, you face a 12-month maximum prison sentence and a $3,250 fine. Do you understand that?
Yes, sir.
Do you understand that your guilty plea may result in a driver's license suspension of between 6 months and 5 years?
Yes, sir.
Do you understand your felony conviction will prevent you from owning or possessing a firearm?
Yes, sir.
Do you understand if a prison term is imposed in this case, you might have to serve a period of post-release control as part of your sentence for up to 2 years under the parole authority?
Yes, sir.
If you are placed on post-release control and violate any conditions, the parole authority could send you back to prison for up to 6 months. Do you understand that?
Yes, sir.
If that violation is a new felony, then you could get an additional consecutive prison sentence for that violation. Do you understand that?
Yes, sir.
If that were to occur, the maximum prison sentence for the violation would be the greater of 12 months or the time left under post-release control. Do you understand that?
Yes, sir.
Do you understand if a prison term is imposed in this case, you are eligible for judicial release?
Yes, sir.
I could place you on community control for up to 5 years, but if you violate any conditions, I could send you to prison for 12 months. Do you understand that?
Yes, sir.
Has anybody promised you I would be lenient on you just because you're pleading guilty today?
No.
Has anybody promised you what I will sentence you to in this case?
No.
Do you understand I don't have to follow the sentencing recommendation of either the prosecutor or your lawyer?
Yes, sir.
Have you had enough time to talk with Mr. Mulkey before pleading guilty today?
Yes, sir.
Has he discussed everything about your case and answered all of your questions?
Yes, sir.
Are you satisfied with the advice he has given you?
Yes, sir.
Have you been threatened or coerced in any way to plead guilty today?
No, sir.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes, sir.
Do you have any questions?
No, sir.
Ms. Gold, if that case went to trial, what would the evidence show?
Thank you, Your Honor. The facts would show that on February 10th, 2026, officers conducted a traffic stop on a vehicle that the defendant was driving, gained probable cause to search that vehicle, and located pipes with suspected cocaine. They were taken to the Lake County Crime Lab and did test positive for cocaine, a Schedule II controlled substance. On February 28th, 2026, officers tried to arrest the defendant on a warrant for this incident and without privilege to do so and with purpose to prevent, obstruct, or delay the performance of a public official. The defendant hid in his basement in an attempt to evade arrest.
All right, Mr. Mulkey, anything to add to those facts?
No, Your Honor.
Mr. Liebeck, did you hear what Ms. Gold said, that the facts would show if the case went to a trial?
Yes, sir.
Are those facts true?
Yes, sir.
What is your plea to count 1, possession of cocaine, a felony 5?
Guilty.
And what is your plea to the forfeiture specification?
Guilty.
What is your plea to count 2, obstructing official business, a misdemeanor 2?
Guilty.
Mr. Mulkey?
$320.26.
Your Honor, I've witnessed Mr. Mulkey and the defendant sign the written plea of guilty, and I have signed it myself.
Mr. Liebeck, is this your signature on the written plea of guilty?
Yes, sir.
Did you sign it voluntarily?
Yes, sir.
Do you want me to accept your written plea of guilty?
Yes, please.
I'll accept the written plea of guilty. Defendant was present when Mr. Mulkey advised of all of his rights, made a knowing, intelligent, and voluntary waiver. He understands the nature of the charge, the consequence of his guilty plea, and the maximum penalty. Finds to be knowing, intelligent, and voluntary, will accept his plea of guilty and find him guilty of count 1, possession of cocaine, a felony 5, and the specification, and count 2, obstructing official business, a misdemeanor 2. Mr. Mulkey, as to his right to a pre-sentence report in this case?
Your Honor, we have a recent one dated March 4, 2026. We would ask the court to incorporate and use that pre-sentence report, assuming the court is going to proceed to sentencing in
All
both
right,
matters.
is it his position to waive his right to a separate pre-sentence report on this case?
Yes, Your Honor.
All right, as to any reason not to proceed to sentencing?
No, Your Honor.
Okay, as to 26-325, Mr. Mulkey?
As to 26-325, Your Honor, my client is 39 years old. He recognizes that he does have a substance abuse problem. Along with that, Your Honor, he is trying to do what he can in terms of making a life for himself by way of landscaping business that he runs. He's very involved in that business. He understands and recognizes a need for treatment. He understands that the jail treatment program as well as NeoCap are certainly possibilities for him. He'd like the opportunity to demonstrate to this court on this FI possession that he could benefit from outpatient treatment. During my conferences with him, he's indicated a great concern for maintaining and administrating his landscaping business and balancing that with the need for treatment. He'd be willing to follow all of the court's orders. I think by pleading by way of information here today, he's acknowledging it may have taken him a little bit of time to come to that realization, but he has nevertheless come to that realization, Judge, and he understands that part of community control is showing up at probation and certainly testing negative for any illegal substances, cocaine or otherwise, and he would like the opportunity to demonstrate to the court that he can do all of that. He is prepared to accept the consequences today in that matter, Your Honor. Thank you.
Mr. Liebeck, what would you like to tell me about that you would like me to consider for sentencing for 26-325 and for 25-15-46?
I like probation. I'd like to, you know, probation, and I can do IOP and report and, you know, give a negative test every time. And I'll report as often as you need me to. But I would like to at least be able to get back to living my normal life, so I can get back to running my business.
What are
Today
you
is
gonna
the
do
first day.
about, what are you gonna do about the drug problem?
I'm gonna go to IOP,
And do what?
get active in the programs, find a sponsor, work the steps again.
You said in the pre-sentence report on the 25 case that you were forced to take responsibility for the drugs that were not yours.
I wasn't
And that the
thinking
only
straight.
reason that you admitted what you admitted was because you repeatedly asked the police officers to allow you to make phone calls, and they wouldn't make you phone calls, and they wouldn't let you make a phone call until you admitted what you did with those drugs.
I was under the influence then.
You were under the influence when?
I was under the influence when I made those statements.
Okay. Well, so when you went for your pre-sentence interview on March 4th, you were high
I had smoked the day prior,
the day prior?
a couple days prior, yeah.
Okay, so you were still high from smoking a couple days prior?
Mhm.
Yes?
I mean, it was still in my system. I don't know.
I
just
know it
wasn't-
was in your system because you tested positive, but were you under the influence of that substance 2 days after you smoked it?
No,
Okay, so then why did you tell Mr. Clement that you only admitted this stuff, that you had knowledge and moved the stuff because in order to make a phone call, the police made you admit that?
I don't know.
You don't know? Well, I don't know, you're the one that said it, so you
Right.
tell me why you said it. Is it true?
No,
Then why did you say it?
I don't know why I said it.
Okay. Because if that were true, then you should go to trial on this thing. If you didn't know anything about any drugs and just told the police what you told them, so they would let you make a phone call, then you should go to trial. Why would you not want to go to trial on that?
Right?
Huh?
I understand
You understand what?
that I shouldn't have said it.
Okay, so when you tell me what you intend to do if placed on probation, why would I believe that when you just told me that you told Mr. Clement a lie just 2-3 weeks ago? Where's your credibility in telling me what you will do?
I mean, I don't know.
You don't have any. That's the answer.
Right?
How long you been playing around with crack cocaine?
Too long. Since I was 28. On and off. Stayed sober for quite a few years, 8 years.
Well, why did you start again?
I relapsed
Why?
because of all this,
Because of all what?
everything that had happened.
Well,
I know.
you had relapsed before all this happened.
Yeah, a couple
So-
days prior to that, just stress.
Anything else you want to say?
No.
Ms. Gold?
Thank you, Your Honor. The state is asking for a sentence of community control sanctions. The state is asking that JTP or NeoCap be a part of those community control sanctions.
right, I've reviewed the pre-sentence report, listened to Mr. Liebeck, listened to counsel, considered all the provisions in 29, 29, 11, 12, and 13. On each case, I'm going to put you on community control for a period of 4 years. On the 26 case, I'm going to serve 90 days in jail with credit for, make that on the 25 case, 90 days in jail with credit for 43. That's only on the 26, 15, 25, 15, 46 case. On both cases then, the last 30 days you're in jail, you'll be in a jail treatment program, complete it and follow the recommendations. You're to have no drugs or alcohol and you'll be screened. You're going to complete the decision points program and follow those recommendations. Get a valid driver's license, obtain and maintain full employment, attend at least 3 AA or NA meetings a week, and get a sponsor and pay the costs and supervision fees. Mr. Clement, any other terms? Mr. Liebeck, do you understand the terms of your community control?
Yes, sir.
Do you have any questions about it?
Is there any way I can get 15 to 30 days to get my affairs in order?
No, because you'll be out using cocaine. Any other questions?
No, sir.
If you don't comply with the terms, the state will file a motion to terminate your community control, and if I find you violated, then you face 12 months in prison on the 26 case and 12 months in prison on the 25 case. You understand that?
Yes, sir.
Anything else, Ms. Gold?
Forfeiture of items.
Forfeited? Anything else? Mr. Mulkey?
No, Your Honor.
All right, we're adjourned.
All rise.